The Department of Justice and Constitutional Development seeks to change the Trespass Act. In a published draft, there are calls for comment that are aimed at repealing the Trespass Act number 6 of 1959. We're joined by Chrispin Phiri, spokesperson of the Department of Justice and Constitutional Development. Chrispin, thank you very much for availing yourself this morning. So maybe talk us through how we find ourselves here. What's the reason behind calling for this change?
Thank you for having me, Tutu. One of the priorities that Minister Lamula had identified for the sixth administration was to ensure that we repeal and reform old era apartheid laws. Some of them are not overtly unconstitutional, and this is one of them, for instance, the Trespass Act. So it still applies today, although it's not overtly unconstitutional, but when we study it quite carefully, we understand that it actually may not be very compatible for a constitutional democracy. So we need to completely revamp it and introduce laws that are straight up right in line with our constitutional democracy. So for instance, the Trespassing Act of 1959 was designed in its nature to ensure that people of a particular hue or color don't gather in a particular area, and if they do gather in a particular area, they would not be able to meet there. Although some of the sections of this old act have been substantially repealed and are no longer applicable, we do find that in the current era, for instance, if you put this act together with, for instance, something like the Prevention of Illegal Occupation Act or PIA, we find that suddenly they don't speak to each other because this act doesn't envision that someone could be in their own property but somehow be deemed to have illegally occupied that. So those are some of the things that we are trying to reconcile and readjust.
Right, so it deals with private properties as well as public spaces.
Indeed. So it properly defines now what a public space is, and it also places an obligation, a clear obligation on owners of land to clearly demarcate the land. So for instance, you'd be regarded as trespassing if you find yourself on land which is clearly fenced and which clearly has signs that this is private property. And so the law will take its course there. And also gives police a clear demarcation of how they would then define what trespassing is.
It's said that the new bill is a little bit more comprehensive. So broadly, let's just take a look at some of the offences. As you've mentioned, property owners need to give notice either by putting up a clear sign or giving an oral warning to the perpetrator that indicates that their entry is prohibited. It also states, though, that someone caught on or in a premise without the explicit or implied consent of the owner is presumed to be trespassing. Indeed.
But I think the main point is we want to really realign this with some of the current acts that we have in place. So the extension of Security of Tenure Land Act to some extent would also apply here. Your Prevention of Unlawful Occupation Act also would apply here, to ensure that we harmonize our laws so that in the event where someone is deemed to be an illegal occupant of land or trespassing, of course there'll also be an obligation to ensure that the relevant court order is in place. But also you'd have to show the court that we have substantially warned this individual that they're occupying land which doesn't necessarily belong to them, or they're not allowed to be on a particular piece of land. And that is currently the law in terms of PIA. But if you look at the Trespassing Act, one wouldn't have to obtain a court order. So those anomalies are now being realigned to ensure that in every sense of the way, the Constitution is properly applied.
Here's one that I found a little bit confusing. Please assist in clarifying. Trespassers can defend against the charge if there's reasonable belief that they have title or interest on the premises that entitles them to enter the property.
Yes, so for instance, let me give you a classic example. There is an example like this before the court. So someone was deemed to have not paid their bond, and the bank repossessed that property, but they had found that actually they had paid their bond. So that is someone who could have deemed to be a trespasser, but actually they were lawful occupants of that particular property. That's just one random example. But what is important that these are bills currently, it's been put out for public comment. So people will pick up other things where they think, well, this maybe is not in kilter with with the type of society that we would like to live in, and they are very welcome to comment on that and send the comments to the Department of Justice. I think the information is put up quite extensively on our website, who to send it to, and we can process those comments before it becomes law. So after this, once we have processed those comments, as will be post the 16th of September, it will then be processed for Cabinet's consideration, having considered those comments, and it will then again go to our legislature. Rather, it will then go to our legislature, where our legislature will also probably institute a process where they still put out such a bill for public comment. So there will be ample opportunity for South Africans to apply their minds to this proposed act once it becomes a proposed act, and see what type of laws they would like to have around trespassing. But I think the main aim here is we're now saying we're re-engineering our laws to ensure that they really give effect to our constitutional democracy and not necessarily a society that we have inherited, which was a colonial and apartheid society.
Sure. I just want to stick on this last point as well, especially maybe for domestic disputes in a country like ours where you have gender-based violence. If the law says a trespasser can defend against the charge if there's a reasonable belief that they have title or interest on the premise that entitles them to enter the property. If somebody says, well, please do not come back here, or they even have a court order against that person, or even in the absence of a court order, but they feel they're not safe with that person, what then does that mean in this case?
No, there would be a completely different regime of law that applies. You are being protected from being harassed by a particular individual. So there we're looking at your bodily integrity. We're not necessarily looking at someone occupying property or a particular space. So there the law has a duty to protect your bodily integrity and remove someone from your confines who may cause harm to you. So that's a different set altogether.
Fair enough. So where do people go, and how long is the process anticipated to take?
Yeah, so like I said earlier, the information is widely available on social media, but also on our departmental website. And you can comment, and the individuals that are required to receive comments are prominently listed on our website. And we understand that the comments will be closing on the 16th of September. And then after that, we will process the comments as the Department of Justice, and then ultimately ensure that this legislation is put before Parliament for consideration. And then we'll take it from there. I think then we'll hear from the legislators what they think about such a law and how it should be revamped. But like I say, even there, in terms of our laws, members of the public would also be entitled to comment after it has been duly processed by the department and is placed before Parliament.
Sure. Chrispin, just very quickly for us, is this one of many changes that we're going to see in terms of our laws, especially given the reasoning behind it, quite colonial, if you will?
There are a number of changes that have already taken place, substantial changes, but yes, we are looking closely at our laws now. For instance, even the Criminal Procedure Act is a very, very old 1977 act, and if you look at our criminal justice system today and the type of crimes that come through our criminal justice system, it does say that acts like the Criminal Procedure Act need to be reformed. Even acts such as the Extradition Act, it's a 1962 act, and even in its composition as well was an act that was designed around a particular world order. And so now we live in a multilateral society, a multi-institutional society as well. So we need to ensure that we have an act that responds to the type of institutions that we have in a society that is now global. So those are some of the acts that we will be placing before Parliament in due course for reconsideration. One comes to think of the Trust Property Control Act, for instance. It's not an act that ever envisioned that crimes like money laundering would be in place. And now we know that the trusts are being used, for instance, to hide certain benefits. So these are the type of laws that we need to ensure we have in place to deal with the types of crimes like money laundering and so on. So there are a number of substantial reforms that are coming across various acts with various intentions. But ultimately, it's to ensure that we modernize our acts and ensure that they are compliant not only with a constitutional society, but a completely different world order completely. So we're not dealing with a we're not dealing with a pre-Cold War society, for instance, where the world was unipolar. Now we're dealing with a world where we have multilateral relations across the board. And such acts like the Extradition Act need to give effect to that even a Trust Property Control Act would have to ensure that we are in line with international money laundering laws, and so on and so on. So yeah, there's a suite of acts that will be reformed, which will ensure that we give effect to the type of society that we want, but also the type of society that we live in now.
Long time coming. Chrispin Phiri speaks for the Department of Justice and Constitutional Development. Thank you so much for your time this morning.